Hello and welcome to the Minimum Competence episode for Wednesday, May 6, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Musk v. OpenAI continues, publishers suing Meta over AI training, and the Supreme Court's fast-tracked Voting Rights Act ruling. Let's remember, between two evils, choose neither. Between two goods, choose both. And read today's legal news. On this day in legal history, May 6, 1882, President Chester A. Arthur signed the Chinese Exclusion Act into law. The law imposed a 10-year ban on the immigration of Chinese laborers to the United States. It also made Chinese immigrants already in the country ineligible for naturalized citizenship, marking a major turn toward federal immigration restriction. The National Archives describes it as the first significant U.S. law restricting immigration and notes that it targeted an ethnic working group on the theory that it threatened public order. The law grew out of anti-Chinese racism and labor anxiety, especially in the American West, where Chinese workers were blamed for low wages and job competition. Although the act formally applied to, quote, Chinese laborers, its enforcement burdened many Chinese people seeking entry, including those who claimed exempt status. The National Archives also notes that the law helped create a broader framework for later race and class-based exclusionary immigration policies. The act was not temporary in practice. Congress extended it through the Geary Act of 1892, later made the exclusion regime permanent, and did not repeal the ban until 1943, during World War II, when the United States and China were allies. OpenAI President Greg Brockman testified in federal court that Elon Musk once supported changing OpenAI from a nonprofit into a for-profit company, but wanted full control of the organization as part of that shift. Brockman said Musk believed the nonprofit model could not raise enough money to build advanced AI systems. According to Brockman, Musk also said he needed $80 billion in stake to help fund a self-sustaining city on Mars. Brockman described a tense 2017 meeting where Musk allegedly rejected a proposed equity structure, became angry, took a painting made for him by Ilya Sutskever, and left while threatening to pause funding. Musk's lawsuit claims OpenAI and Sam Altman misled him into donating $38 million to a nonprofit that later abandoned its charitable mission in favor of profit. Musk is seeking $150 billion in damages for the nonprofit and wants Altman and Brockman removed from leadership. OpenAI argues that Musk is upset because he left before the company became highly successful and is now trying to gain control while also advancing his own AI company, xAI. Brockman also faced questions about his own financial interests, including testimony that his OpenAI stake is worth nearly $30 billion and evidence of an old diary entry about reaching $1 billion. OpenAI later created a for-profit unit controlled by the nonprofit, which helped it raise massive sums for computing power, hiring, and expansion. Publishers Elsevier, Cengage, Hachette, Macmillan, and McGraw-Hill, along with author Scott Turow, sued Meta in federal court in Manhattan over its AI training practices. The lawsuit claims Meta used millions of copyrighted books and journal articles without permission to train its Llama large language models. The works allegedly include textbooks, scientific publications, and novels. The publishers are seeking class action status so they can represent a broader group of copyright owners. They're also asking for monetary damages. Meta responded that AI training can qualify as fair use and said it plans to fight the case. The publishers argue that using allegedly pirated copies of creative and scholarly works is not the same as lawful innovation. The case joins a growing wave of lawsuits by authors, news organizations, artists, and other creators against AI companies, including Meta, OpenAI, and Anthropic. These lawsuits largely turn on whether using copyrighted works to train AI models is legally protected because the resulting systems create something new and transformative. Courts have not yet settled the issue, and early rulings have pointed in different directions. Anthropic previously resolved one major author lawsuit for $1.5 billion, showing how financially significant these disputes can very quickly become. The U.S. Supreme Court allowed its recent Louisiana voting rights ruling to take effect earlier than usual, clearing the way for political and legal consequences before the November midterm elections. The court's April 29th decision had struck down a Louisiana congressional map that created a second black majority district. That ruling weakened a major part of the Voting Rights Act by limiting challenges to maps that allegedly dilute minority voting power. Normally, the Supreme Court waits 32 days before issuing its formal judgment, giving the losing side time to seek rehearing. Here, the court agreed to speed up the process after a request from the voters who had won the case. The move helps Louisiana Republicans pursue a new congressional map and may weaken lawsuits challenging Governor Jeff Landry's decision to delay the state's May 16th congressional primaries. Some challengers had argued that Landry acted too soon because the Supreme Court's ruling had not yet formally taken effect. Justice Ketanji Brown Jackson dissented, saying the court's accelerated action had created disorder in Louisiana. The case is part of a broader national fight over redistricting, especially as both parties seek advantages in House races. The dispute began after Louisiana drew a second majority black district in 2024 to address a prior court ruling that the old map harmed black voters under the Voting Rights Act of 1965. The Supreme Court later held that the replacement map relied too heavily on race, violating equal protection principles. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcast. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the weakness of the argument has always been that those who choose the lesser evil forget very quickly that they chose evil.